Well, the new Supreme Court term begins Monday. The justices will be considering several cases, including on religious liberty, affirmative action, and voting security. The nation's highest court says that it will continue to provide live audio broadcasts of the arguments. The public is also welcomed back into the proceedings for the first time since March 2020, when it was closed due to the coronavirus pandemic. And we go now to Carrie Severino, president of the Judicial Crisis Network. Carrie, great to have you back on. First off, let's talk about this case regarding religious liberty, its similarity to the Masterpiece Cake Shop case a few years ago, where a Christian bakery owner refused to make a cake for a same-sex wedding. Talk to us about that.
Yeah, the case is called 303 Creative, and it's a similar set of facts where there's a woman who owns a business. In this case, she's designing websites. She wants to be able to design wedding websites. It's obviously a very important factor of that business, but she doesn't want to be forced to design websites that she is morally opposed to. And it's interesting because this case is being argued not just as a religious freedom case, it's actually as a free speech case in this case, although obviously we know that those free speech rights are ones that are particularly under attack for those with religious objections as well. So this is an opportunity for the Supreme Court to come up with a clearer result than they did in the Masterpiece Cake Shop case, in the hopes that maybe we won't have to keep relitigating this same issue again. It will be clear that people can't be forced to speak contrary to their consciences.
Yeah, and I know there was also a lot of attention on two affirmative action cases as well, involving Harvard University and the University of North Carolina. Can you talk to us more about that?
Yeah, so UNC is obviously a public school, and Harvard receives federal funding. And so as such, they're governed by Title VI of the Civil Rights Act, which requires that they don't discriminate on the basis of race. However, the evidence in this case is that, in fact, there is racial discrimination going on at the school. And in particular, it's a discrimination that harms Asian Americans. They have to achieve much higher test scores and grades to be able to be admitted to either of those schools. So the Supreme Court has, again, this is an issue they've looked at several times going back decades, but they've never come down with a very clear answer. And the most recent case on point said basically, we're not comfortable with the idea that they're using race, but we're going to allow it for 25 more years, and by then we ought to be done with this. Well, it's been almost that length of time, and it's clear that this is something that is still persisting in many of these schools. I think this is another opportunity for the Supreme Court to be clear about requirements in federal law that schools be colorblind, and even if they think they're using discrimination for beneficial ends, in things like college admission, this is a zero-sum game, and so other people are being hurt as well when we're choosing based on race rather than based on the student's other characteristics.
Carrie, are there other cases that you're watching right now that are on your radar?
Yeah, this term isn't going to be as many fireworks as last term, but one other important case that's going to be coming up comes out of North Carolina, has to do with the ability that the Constitution gives to state legislatures to determine how federal congressional elections are run. It's very clear in the Constitution, but what happened in North Carolina is, though the North Carolina legislature set voting districts, the North Carolina Supreme Court basically said, nope, we're overruling you. We think that North Carolina law requires something different. And that case is going to go to the Supreme Court to determine whether the words of the Constitution simply mean what they say, that the state legislatures, not their Supreme Courts, are the ones who make the final call here. I think for a court that is originalist as this one, and that's something that we saw so clearly last term, particularly in the Dobbs decision, just saying, let's go back and look at what the words of the Constitution say, I think that should be a pretty easy case. And it just is going to show the consistent originalist understanding of the Constitution that obviously has an application not just in the abortion context or the Second Amendment, as came up last term, but across the board for any constitutional provision.
And we have to leave it right there. Carrie, always great to get your insights. We really appreciate it. Thank you so much.